Yes. For admission, item number 1.
May it please your lordship.
Yes.
This is regarding a contempt application. Now, on several occasions, this honorable court has passed orders for release of the compensation money. The last order was also, there was an order direction by this honorable court for submitting the compliance report. Now, on the last occasion, the government council, the council for the contemptor had placed this document on record, whereby the deputy commissioner, your lordship will kindly peruse this. In the month of March, your lordship will see this, the deputy commissioner was directed to release the compensation money. In fact, the checks have already, this is basically land compensation issue. The checks were already received by him from the central government, from the Union of India. And there was some hiccup in the between, but later on, the state machinery had directed the deputy commissioner to release the money in the month of March. But my instruction today is also that only around 10% of the money has been released, and that too in some small pockets.
In between.
Till date, they have not complied with the order in toto, and only in the name of compliance, some here and there, some money they have released. But in the month of March itself, money was there, the checks were there. The state government at the top, at the highest level, had directed the deputy commissioner to release the money. From March, now we are in May, people are still waiting for this compensation money. And these were issues which were of 2016 and 17. A prolonged litigation was fought. Then in the month of January 2023, a judgment was passed. We filed the contempt later on. And now we are in 2024 May, yet they are waiting for this due compensation money. So I think they are answerable to this.
What is the difficulties if
Your
that be
lordship,
this?
Just
I
they
may
have
be
to
allowed to
read
read this
Which one?
letter.
That
written
I have
to the
just
deputy
placed.
commissioner.
Okay.
Letter is very clear.
Okay.
May I read, your lordship?
Yes, please.
To the deputy commissioner, Peg Nagaland, subject release of damage compensation for properties damaged during the execution for the work 2 laning on Futura Peg Road and Chakapama Zanabuto Road under SARTPNE in the state of Nagaland, in compliance to court order dated 29th to 2024, passed in COP C number 19, 2023. Chagasang Public Organization and another versus Shri Anurag Jain and 2 others. Reference letter such and such. Sir, in inviting a reference to the above cited subject, I am directed to refer to the above court order dated 29 to 2024, passed in COP such and such, and request you to initiate for release of the check amount which has been issued by the Union of India in favor of the petitioners towards damage compensation payment in compliance to the Honorable Court's order dated 29 to 2024. Compliance report may be intimated to this office at an early date. That was the letter written by the Chief Secretary.
Yes.
This 29 to 2024 date of the compliance with the court's order was an order passed in the contempt petition, wherein a strict order was passed that within 7 days, you must submit compliance report. But this is how the mechanism is going on. I mean, they are not, I don't know why. Everything is there, they have to give the money. They're not doing it. What extraneous considerations are maybe involved, that also I'm having some doubts now. Why is the deputy commissioner not releasing? If a specific direction will be given
Deputy
to
Commissioner is respondent.
that is the difficulty, because we had not made him a contemptor. We made the chief
Okay.
secretary of the state a contemptor. Because at that point when we filed this case, it was the state who was not complying with the order. Later on, the state, because he's only an officer of the state, so the chief secretary was made a party as a contemptor. The deputy commissioner was not made a party. But even if the chief secretary is the higher officer, he can always direct his juniors to comply with the
So
orders.
this direction is issued by this is under secretary to the government of
Yes.
Nagaland. So he issued on behalf of the chief secretary.
Chief secretary, yes. Well, I cannot keep on making each and every officers of the government as a party. I will make the highest officer of the state, because the direction was, the initial direction in the repetition was, PIL was, the Union of India will release the money, and thereafter the state government will thereafter do the disbursement work. So when it was not done, I made the chief secretary a party. So finally, the chief secretary have done his part. He has said, yes, the checks are there. I have directed the deputy commissioner to release the money. Now it is at that lowest level that where the disbursement is going to take place, this delay is happening.
What according to the state is the difficulties on the part of the deputy commissioner to release because if the money is there.
They will direct the deputy commissioner.
My lord, by this letter, direction was given to Deputy Commissioner Pat to release the damage compensation.
This was in the March.
Yes, ma'am.
But then they said that in between also, few of them, in between.
Only a few amount of money has been released in few places, not everywhere. Entire money is 61 crores, the due compensation amount. Out of that, only around 5-6 crores, which what has been released till now. And that too in some areas, that's what my instructions are. Specific instructions that I received in the morning today. This is the situation. I mean, the chief secretary should simply direct his officer, the subordinate officer, to comply with the order. He cannot just say that I have got no role to play here. The chief secretary directs the deputy secretary, the deputy commissioner, or otherwise he will so cause him. If he is not doing his duty, if there is a misconduct on his part, then they will have to so cause him. Simply by showing this letter before this court and saying, I directed the deputy commissioner, what he is doing, I don't know. Maybe that will not lie in the mouth of the chief secretary. It is his duty to ensure that the compliance happens. Can't he direct his subordinate officer to comply? Why do I need to make him a party here?
So the state in the last occasion submit that the state for release of the damage compensation. This is 12. The same thing.
Yes, Lord. Last occasion also, like, actually there was a consent order. We decided to take time so that the compliance can happen. But till date now, 2 months have gone, yet they're not doing anything. The money is lying in their account. In my humble submission, let the chief secretary be directed in very strict words
Yes.
to direct
Lordship,
his
if I may-
subordinate to comply.
Yes.
If I may be allowed to furnish this.
What is that?
This is a direction from the ministry. Directing the money has to be deposited in the account of the Deputy Commissioner Pat. If I may be allowed to read you.
This
It's
was
okay.
this was earlier.
These
And
are
thereafter
all
also-
taken care of. These were issues which were raised and all were taken care of. Now it is only regarding the release. Let the chief
This
secretary.
probably has been reflected in the earlier order.
Yes, Rossi. These are all been argued by him earlier and have been taken care of.
So, but now it is now
Only regarding compliance.
with the deputy commissioner only, I think the money has already been transferred.
Yes, Lordship, it is with him.
Then
In fact, he is releasing
What
also.
difficulties?
He is releasing
So-
also. But then he is not releasing in the manner that is required to be released. For last 2 months, he is not doing his work in an efficacious manner. He is dilly-dallying with the matter.
He should be doing what he's supposed to do.
Exactly,
Yes,
exactly.
ma'am.
So, what to do? Then you,
Let the chief secretary be
the
directed.
chief secretary, you obtain instruction what is the present position and why the deputy commissioner, what is the difficulties on the
Yes.
part of the deputy commissioner? If there is no difficulties, then why he is not releasing? What
Yes.
interest he has?
Yes, ma'am.
Then obtain instruction and then file affidavit in the form of affidavit. If
Yes.
there is any difficulties, we'll
Yes,
see.
let it be on
Yes, ma'am.
record.
On record. So one, next,
My lord, I may be granted 3 weeks time.
On 3rd of June then, Lordship.
3rd of June.
3rd of June. I'm an association lawyer, so 3rd of June if it's otherwise not inconvenient.
30 is, Wednesday.
No, it's a Monday. 3rd is a Monday. Second division bench is there. 3rd, I think.
3rd of June.
3rd of June.
Okay, it's Monday. Heard Mr. A. Sharma, Land Council for the petitioner staff. Also heard Mr. L.P. Sankdam,
Health is-
Land Additional Agent for the respondent staff. What is the last order where it says that the money has been money has already been transferred to Deputy Commissioner, and despite of that, the DC has not yet released?
There was one order,
Has it been reflected in the order?
in the last to last order, it was reflected
Okay, so where do,
that regarding that money,
it has come on record. So where do we find?
I apologize, I don't have the certified order copy with
Okay,
me.
compare with the orders, the release, check amount.
This is the admitted position. This is an admitted
Okay.
position that, because this letter itself indicates, this letter of March itself
Hmm.
indicates for release of the check amount. The word check amount is there.
Okay.
You also can refer to this letter also itself.
Okay.
By Undersecretary's letter of the
So
month.
this letter was also placed, already placed earlier before this court?
Yes, on the last occasion,
Okay, yes, yes.
it was
The
placed.
department
Therefore,
has
we took that.
taken step. Okay, the Learning Council for the petition of Mr. S. Sharma submit that despite of the direction, this is direction for release.
Yes, Lordship. The Undersecretary writes to the Deputy
Despite
Commissioner
of the direction
for release of the check amount.
for release of the check amount.
Your Worship,
No, direction by, yes,
I'm applying for response number 1, as Union of India.
okay.
We have
So he's,
already released the whole
okay,
amount.
Yangarbati,
So,
his present also may be recorded, huh?
So
And Mr. Yangarbati Lanaka, CGS, huh? Yes,
I pray that the deputy commissioner may be personally allowed to pay favor for the court and explain why he is not releasing
so,
the.
so the
Because-
difficulty is that he is not met, he has not.
Yes,
been
and
met-
that, but
met
it
as a
is
party.
a deputy commissioner,
So-
deputy.
So let
commissioner-
us see, let us see what is the difficulties. Let the chief secretary ask the deputy
ma'am.
commissioner,
Yes,
and if it is on the part of the deputy commissioner, then you see departmentally also the chief
Yes.
secretary can always take action against the
Exactly.
deputy
Yes,
commissioner.
That is what I'm saying.
So because he is not a party here
Yes, yes.
before this court. So despite of the direction given to the deputy commissioner by the undersecretary to the government of Nagaland for release of where,
That third line, release of the check amount,
with the release of the check amount,
which has been issued by
which has been issued by the Union of India in favor of the
Petitioners.
petitioner, the deputy commissioner is not releasing the amounts,
the entire amount, I would
the
say,
entire amount
till now.
dues to the petitioner till now. Stop. Stop. This letter, you mentioned this letter, 12, huh? Direction by the, to the deputy commissioner by under secretary so and so by letter dated 12 March, huh? Okay, release of so and so, not release, huh? Okay, stop. Huh? In view, stop, huh? The Learning Council for the respondent. Your correspondent number one, two summits. Respondent two cell obtain necessary instruction from from the chief secretary.
No, so for the deputy commissioner, because he is the chief secretary.
Hmm?
He is the chief. Respondent number 2
Hmm.
is the chief secretary.
Yes.
So respondent number 2 will seek instructions
Hmm.
from the deputy commissioner.
Okay, the respondent number, the land counsel for the petition, the respondent number 2 shall seek instructions from the chief secretary as to why the deputy commissioner is not releasing the amount despite of his direction.
He is appearing for the chief secretary.
Chief secretary, the
Yes,
chief
sir.
secretary, because
He will obtain instructions from
he will
the.
obtain instruction from the chief secretary only,
Yes.
not from the deputy commissioner. Hmm? Hmm. Because he'll obtain from the chief secretary, and the chief secretary will find
Yes,
out
I understand.
why.
As a counsel, he will seek. Yes,
Yes,
I
he'll
understand. I
seek.
understand.
Okay. And file in affidavit form on the next date. Okay.
Yes.
List this matter again on
3rd of June.
3rd of June.
The lawsuit can kindly observe
Hmm.
that it is expected by then they should comply with the order. So otherwise, they are just delaying the matter like anything.
Hmm.
It is expected by this honorable court that
Now find out, is it, so under the circumstances, is it possible to implement the deputy commissioner also? No.
I can always do that. That option is always available. I can do that. But
Hmm.
I can
Because
always do
now, by virtue of these transaction orders, it appears that the deputy commissioner is also necessary party, it appears,
that. As of now, the quantum is happening at his status.
in
stage
his
itself.
level only.
Yes, his level. That is true. But
You also explore in the meantime.
my predicament is if I start
Hmm.
impleading officers, tomorrow the deputy commissioner will come here and say
Hmm.
that my subordinate, maybe the ADC, he is not obeying my orders. So
Hmm.
how long
But-
will I make parties after
Right,
parties?
right,
It's the
right.
chief secretary who is the
The
head.
lordship,
He
Hmm.
should.
DC PEG should be a necessary party.
That I
Because
will do. That
he
is not an issue.
undertake the verification for damage compensation, because who are the genuine landowners?
very beginning,
That
you
has to
should
be
have
explained by the deputy
Hmm.
commissioner. So
Party.
he has to be made necessary.
You explore because it's your case.
Yes.
It's your case. Otherwise, the direction, direction will go only indirectly
I
only.
understand.
Because
Yes.
unless the chief secretary take action against the deputy commissioner, we can't because he is not a party.
Yes, ma'am.
I understand.
Hmm.
Situation has
So-
evolved now of this nature. So yes, I'll do that needful.
It is made clear that on the next date, the respondent number 2 shall apprise this court the reality of the ground, ne?
Yes,
Ground reality.
ground reality.
Mm. Ground reality, especially ground reality, especially on the question as to why, as to especially on the question, especially on the difficulties on the part of the deputy commissioner, if any,
For expeditious release of the compensation.
for experience release of the
Compensation.
compensation,
Damage compensation,
release of the
damage compensation.
damage
damage
compensation to the petitioner.
Yes.
Okay.
Obliged, sir. On 3rd of June.
Your lordship, DC PEG may be implemented as a necessary.
This effect, you can't, he need to take steps. So he will explore, and if he think that this is still not required, not necessary party, it's up to him.
Because I'll have to take instructions from my clients on.
Yes.
Suddenly I cannot just commit that I'll make him a party.
Hmm.
I'll take my instructions from my clients. If necessary, I'll move an application for his implement.
Mr. Sama further submits that he'll take instruction from his client if the before making deputy commissioner as a necessary party into the case. Okay.
Obliged. Sir.
For admission, item number 2.
May it please your lordship. This is the
Yes.
bail application of 3 under trial prisoners, and the lordship had in fact had an occasion of dealing with this matter at one point of time also. Now, the accused before your lordships
No, just a minute.
Last week.
Whether the
yes.
record is necessary, not necessary.
Not necessary because there is no change of circumstances since the rejection of the earlier bail application.
There-
What is your submission then if there is no change of any circumstances
Yes,
from?
no
the first-
ground, no
yes,
fresh
from-
grounds, your lordship.
There
Your,
are
your earlier bail was rejected.
Yeah,
there are two
What is the
arguments.
new ground here
Yes,
then?
there are two arguments on this. Yes,
Ah.
there is a new ground. I'm coming to that.
Okay.
But before that,
Hmm.
what I would like to submit is
Hmm.
in a regular bail application,
Hmm.
each day
Hmm.
behind the bars
Hmm.
is giving rise to a new cause of action, because
Hmm.
ultimately Article 21,
Hmm.
my personal
No, that is
liberty,
there. Yes,
is
that
at
is
stake.
there. Hmm.
Had it been an anticipatory bail application,
That is there.
the status would have remained the same, that
Hmm.
I am asking for a privilege of pre-arrest bail. Now I come to this honorable court rejects that. Thereafter, I again cannot come asking for the same privilege of pre-arrest bail, unless and until there are some changing situations attached to the case. But in the matter of a regular bail application, my
One-
submission
Hmm.
subject to correction of this honorable court.
Yeah.
In a regular bail application,
Yes.
each day is a new cause of action, because
Yes,
I am behind
because
the
he has
bars.
been in the longer,
Yes,
he-
so therefore, the length of detention,
Hmm.
the daily I gain language
So-
in the bar is a new cause of action.
Hmm.
That is one aspect. For therefore, this
Other than that, what I'm asking.
yes.
Hmm.
The other issue, if your lordship is not inclined to accept my submission on that,
Hmm.
the other issue, what madam is saying, that there is no ground. The biggest ground is that the entire proceedings,
Hmm.
the trial proceedings are under stay. And this is a new ground which was not urged when this bail application was moved before this honorable court, when your lordship was handling this matter at that point of time. So when the entire proceedings are being stayed, because the transfer petition was filed, there was a suo motu case. The matter was supposed to be transferred from that court to another court. It was taken up by this honorable court on a suo motu basis, and there is a stay of the proceedings. Now, the initial stay order was given in the month of November 2023. We are now in May. Till the stay order is continuing, the proceedings are under stay. So at one hand, the trial is under stay. And on the other hand, these under trial prisoners are behind the bars without the privilege of getting their liberty.
That's it.
The Supreme Court, in various judgments, I have also brought a judgment, latest judgment, have said that this is a very important or a very significant ground to be considered. The delay in the trial. Now we are staring at a situation where the trial, forget about the delay, the trial itself is in a stalemate situation. It is under stay. There is no trial happening at this point of time. So whether this delay, which is not attributable to the petitioners, is not a significant ground based on which the honorable court can grant us bail. Because ultimately, my personal liberty is at stake. On merit also, I can show that these 3 petitioners who are before your lordships were not involved with the actual murder. The charge sheet itself categorically and clearly reveals that in location C, where the actual murder took place, basically the beating by a wooden stick and killing the person, was done by 3 other persons, and these 3 persons was in location D, which was a different location, wherein they were stopping the car and the driver, and they were assaulting the driver in the car, that was only an issue of assault, that nothing happened to him. And the charge sheet, there are statements which would categorically state that those 3 persons from location C who did the killing, they came and joined them, and then thereafter they left. So these 3 persons were otherwise, maybe your lordship can say that they were in the entire conspiracy.
120 and 34 is also there.
Yes,
Hmm.
but what I'm trying to harp upon is that
Hmm.
the actual 302 offense basically would be attributable to the other 3 petitioners, other 3 accused who are not before this honorable court. These 3 maybe were a part of the conspiracy, the larger conspiracy, but yes, at the time or at the place of occurrence of the murder, the action of murder, these 3 people were not there. The charge sheet would clearly reveal that. In fact, your lordship has also, I've gone through your lordship's order, the detailed order. Lordship has quoted that issue. But then at that point of time, when this matter came to lordship had stated that at this stage, I'm not inclined to grant bail. But that was, I think, in the month of May. Now, November or May? I'm just placing that.
Okay.
On October. On
Oh,
October
the
2023, Lordship was of the view.
Bail was rejected.
Yes, Lordship.
You have annexed that one.
Yes, Lordship.
Okay. Oh,
So on page 42, Lordship.
okay.
So, the Lordship had given a very detailed order, and in fact, the entire facts are very clearly stated and accurately stated here. I have nothing to add to this.
Hmm.
My only humble submission before Honorable Court would be the present change of circumstances, the length of detention, therefore now probably entitles the present petitioners who are seeking bail before the Honorable Court for the privilege of regular bail, because they have been arrested in March 2023, Your Lordship. It is now more than 14 months that they are behind the bars. And I'll also place, if Your Lordship allows me, to show and indicate and in fact prove that these three persons were not involved with the actual incident of murder. They were there at a different location, manhandling and assaulting the driver of the vehicle. And it was a passenger of the vehicle who was killed at a different location by three different persons.
Okay.
So your Lordship has stated at paragraph 40, at the page 47, that I'm not inclined to interfere with the trial of the case by allowing this bail application at this stage. Page 47.
Yes.
The last observation of this Honorable Court. I am not inclined to interfere with the trial of the case by allowing this bail application at this stage. So your Lordship had qualified your Lordship's order by saying that this is an order that I am passing at this stage because I do not want to, this Honorable Court wants to interfere with the trial. But today, the changed circumstances that, if I may place your Lordship, is at page 50. The very trial is under stay. From 2/11/2023, that is after your Lordship's order has been passed, page 50, your Lordship.
Okay.
Your Lordship's order was passed on
Yes.
31/10/2023.
Yes.
Now, this transfer petition suo motu 4 of 2023, the first order was passed on, Lordship will record that, Lordship will just take a note of that, was passed on. The first order in this, Lordship will come to page 50,
Yes.
50.
Yes.
This is transfer petition suo motu 4 of 2023. I have annexed one order here, the last order, the recent order when we filed this application. But if your Lordship will kindly note that this transfer petition was first taken up by this Honorable Court on 2/11/2023, 2nd of November 2023.
Suo motu.
Yes, Lordship. These are all admitted positions from record I am stating.
Taken on.
Taken on 2/11/2023.
Okay.
And that was the day when the proceedings were stayed. ZR case number 30, Mokoksong PS, ZR case number 34 of 2023 was stayed
It was by the single bench only.
by the division bench, Lordship.
By the DB.
DB, this is the DB's order.
It was first suo motu
By the
case.
DB itself. Yes, Lordship.
DB itself.
DB itself.
Probably. Is it?
Yes.
Lordship.
This is an admitted position, Lordship.
Just a minute.
Suo motu taken up by the DB itself.
Okay.
And so the proceedings were stayed on 2/11/2023. This order that I have annexed at page 50 was the latest order when we had filed this present bail application. Just to indicate at the last page, page 53.
Your Lordship, if I'm not wrong, Your Lordship, it has been taken up by the Chief Justice and it was referred to Division Bench, Your Lordship.
Okay.
Yes, Your Lordship.
No, just a minute. This was, is this a case where the government has transferred the case
Yes, yes.
and probably this was first taken up by the single bench,
No, it was taken up by the.
straight away
division.
by the DV.
Yes, no, first, yes, by SB, and then it was referred to division bench
Yes,
again.
single
Yes,
bench. I
yes,
remember.
yes.
I think
Oh,
Yes,
I'm
yes.
not a party, so I don't.
Yes, yes.
Mm.
Exactly.
And they were the
it,
party
it was
there.
it was
Yes.
placed before me, this court only.
Yes, your lordship.
Hmm.
Yes. And then it
So
was referred to division bench.
Hmm,
your lordship.
because there was an order by the
Yes.
government to transfer the criminal case from
Yes,
one court
yes.
to another court.
Yes.
And
yes,
then
your lordship.
since this involves with, because the single bench observed, found that this involves with the law,
Yes, yes.
and this has to be decided by the
By-
DV.
yes.
That is
Has
why
the
it was
knowledge of
placed.
this.
Yes,
Okay,
yes.
yes,
your
I
lordship.
remember.
Yes.
So,
So I just wanted to show at page 53,
hmm,
just to indicate that the stay order is still in continuation. The last paragraph, page 53, paragraph 13.
hmm,
Stay of the proceedings of GR case number 34 of 23, which was ordered, it's recorded here,
yes.
which was, yes, I stand corrected, Lord.
Hmm,
Which was ordered by the learned single judge by order dated 2/11. Yeah, 2/11 is here, Lord.
Mm.
2/11/23
this
stands
was-
extended till the next date of filing. The matter was supposed to be listed on 5/4/2024. On that day, it was again extended, and now the matter is fixed after 3 weeks and probably I think on 22nd May 2024. So what I'm trying to impress upon your lordship is that the trial is on one hand stayed, and there is a proceeding going on regarding the aspect or the legal aspect of this transfer. So at one point, the trial is not happening. On the other hand, these accused persons for last 14 months are languishing behind the jail, and there has been, therefore, now there will be a delay in this trial. And the Supreme Court has said that this is a very significant aspect to be looked into by an honorable court while dealing with the bail application for grant of bail. As it is, the length of detention lordship has seen, it is 14 months.
Yes, it's a 14-month.
14 months.
And then,
Life
then-
imprisonment,
and
your
then
lordship.
apparently, of course, it appears that the trial is not happening.
The trial is not happening because of the stay. Now
Because of
they
the
are,
stay.
yes, they should press for that suo motu petition, your lordship, because they
Yes.
were the party. They have
According
been
to them,
seeking
it
time-
appears that yes, that there is a change of situation because they are
Your
just stay.
lordship, stay of trial cannot be,
No,
your lordship,
this-
after the stay, they have moved to bail application. And this honorable court has observed, if your lordship may kindly allow me to place the court order.
Yes.
It has been rejected that stay of trial cannot be a change of circumstances, your
Hmm.
lordship. That was observed, your lordship.
Okay.
Uh,
No, what I'm saying is that
Lordship.
the length of the accused person having
Lordship,
been lodged inside a custody
lordship,
without trial. So it's
lordship.
been now 14
14
months.
months, your
I'll place
lordship.
the
And then-
judgments, Lord.
And then there is also immediately probably this may also, of course, they need to press before the DV,
Yes, your lordship.
but
So your lordship may kindly allow me to place the
Yes,
judgment,
yes,
your
sir.
lordship.
stay is since 2/11,
Stay is 2/11.
since 2/11.
Yes, and bail application was filed, and order was passed on 14/12, your lordship. The second judgment, the first is your lordship's order.
Hmm.
The second bail application number 29/2023, your lordship, dated 14/12/2023.
Second is
That is also annexed here.
15/12,
48.
15/12.
Yes, your
That
lordship.
is annexed at page 48
Your
of this
lordship.
bail application.
Okay, mayor.
Here
stay.
in this bail application also, they have taken that ground that because of the stay
Okay,
of
in the opinion of the court,
trial.
merely
Yes.
staying, para 6.
Your lordship, that is bail application 30, yes. Bail application 30, if your lordship may see para 6, yes, your lordship.
Let me see. Can I just see it?
One of the applicant is the A3, accused, the co-accused,
This one.
yes.
Only one person has filed the case.
One person, yes.
This
But
is
it's
not
the
our
same, your
application.
lordship.
It is not
No,
our.
no, your lordship.
This
One
is-
of the
this is-
accused is
He is not the
Before-
petitioner.
No, not the petitioner here.
accused.
This is a different petitioner.
No,
The
no, your
cases
lordship.
that we have filed. are
One of the
annexed, Lord.
applicant is a party in that bail
Okay.
application. Yes, your lordship.
Okay, here also.
Yes, your lordship. Accused 3. Chidek Mayang is a party, your lordship.
Okay,
Yes. So your lordship, since this court has clearly observed that change,
saying that.
your lordship, stay of trial cannot be term as a change in circumstances, your lordship. This repetition, this application is fit to be dismissed, your lordship. Allowing will run counter to this judgment, your lordship.
Hmm.
Also, my clear instruction as I'm receiving from my learned friend, the accused or the petitioner herein had never given consent for filing this case. The bail amendment 30. And in fact, I did not see his name also here in the array of parties.
The said accused person are A1, A2, A3, A4, A5, A6, and A7, your lordship.
The accused persons, A3 is involved.
Yes, A3,
A3 is here also.
here, yes.
But
They are same.
A8 and A9. We are here
8
for
and 9.
A3, 8 and 9, Lordship.
Yes.
Whether they are a party in this bail application or not, your
no.
lordship.
In the,
The grounds, your lordship.
In
I kindly
connection with the
see,
same
yes,
case.
yes,
okay.
arising out of the same
This
GR.
will be a situation of a very difficult or dangerous situation. Then they will not be able to seek bail ever.
No, it's not
Is
that, your
that
lordship.
can that be a
If
ground?
liberty was given, only if there is change of circumstances, he can file, your lordship. That was the
Change
observation.
of circumstances is yes. Every day behind the bars is a change of circumstances. Each day my personal liberty is been infringed upon. That was the Supreme Court says. I'll place the Supreme Court judgments now. After losses perishes these judgments, I'll place the Supreme Court judgments. And in this case, where the petitioners had moved the bail application, bail
In
up to
this
29,
case, your
this
lordship-
issue was not there regarding this.
Your lordship, the grounds taken is, your lordship, at para 7 and 8, your lordship.
Of the petition.
Yes, your lordship. They have taken the stay of trial as the ground, and that is not a fresh ground, your lordship. Because stay of trial has been, as a ground has been rejected, your lordship, in bail application 13. And what if this bail application is allowed, then it will run counter to the order passed in bail application 30 of 2023.
That is only one of my ground. The other ground is the length of detention also.
Length of detention has to be reasonable. The offense is life imprisonment, 14 months, your lordship.
I will
Not
place
even
from the
half
charge
of
sheet.
the,
I
not
will
even
place
half
from
of
the
the
charge sheet to
imprisonment.
indicate
Yes, yes, your lordship.
how they are involved and
Yes,
to what
yes.
extent they are involved.
Yes,
I'll place
yes.
that.
Charge sheet is very clear, your lordship. Charges.
There are the order copies, judgment copies. What will be on this thing? What is it? I can't find it. Find it out.
You said 377 days.
Till then also,
Okay.
till filing of this application. They were arrested on 2nd March 2023. So basically on the first week of March.
Your ground is at para.
That's it.
Your ground for the claiming bail is para 7 and 8. And
Yes, Lordship.
7, 8.
7, 8.
Okay.
7, 8 and 9 we have stated regarding the Article 21, the personal liberty.
Okay.
Because we are under trial prisoners, we are yet to be proved guilty. The Indian criminal jurisprudence states that we are innocent till found to be guilty.
How many of them are still there?
Nine,
It's,
all
nine
of them.
more of them.
Yes, because
Okay. Hmm.
they have a plan carried out accordingly
Hmm.
in murdering the deceased, your lordship.
Hmm.
It's a heinous crime, your lordship.
When this DB is fixed next
PP is fixed
My instruction
somewhere
is
in the
on-
month of June.
June?
Yes, on the prayer of the accused.
Okay.
Yes. They also appeared and they have sought time to file a reply.
Okay.
So Without pressing that suo motu, how can they bring the ground
Okay.
stay of trial as a
Since
ground?
we are a
Your
party
Lordship?
there, obviously we will
It
take our
cannot, Your
stand. We
Lordship.
cannot simply come and say that we are agreeable to anything and everything.
If they are
If
aggrieved
we
by,
are made a party, we'll obviously will file our reply.
if they are aggrieved
What
by
is
the
wrong
stay
in
of
that?
trial, they should press, Your Lordship, that suo motu petition, Your Lordship. It cannot be a ground for bail, Your Lordship.
That is only one of the grounds. If I may place the Supreme Court
So
justice
these-
also.
Just a minute.
Yes, Lord.
This, in respect of this
A3.
just a minute. Earlier, the petition,
Yes, Lord.
bail application 17, earlier was for, in respect of, okay, which one?
In
Accused member?
respect of 5 of them accused.
Five
member,
of them.
The here involved.
Here, yes, 3, all of them are there in this,
Okay.
Page
A3,
43. Page
A,
43.
A3,
Oh, 8, 9 also, okay.
A3, A8
Okay,
and
okay.
A9. Yes,
And
3 of them.
thereafter this A3,
Yes.
this was in 31,
Again,
on
in,
31,
yes,
10.
yes.
Then on 1510, 1512, A3 again filed.
A3 along with other co-accused has filed, Your
Okay,
Lordship.
so
Yes.
this, so for A3, it will be a third.
Third
subsequent-
bail application, yes. Your
Third
Lordship.
subsequent,
Yes,
subsequent bail.
the
application.
subsequent, yes.
Mm.
For 8 and 9, I think it will be
Second,
second.
yes.
Eight and 9, okay, this is second,
Second.
that is third, okay. Okay. So, okay, we pass over.
I just place the two judgments.
Judgment.
Yes,
Okay.
Lord.
Mm.
On length of detention. The first judgment is 2011. State of Kerala versus Ranif.
Okay,
Paragraph 15.
15, this is
This is a case of Unlawful Activity Prevention Act,
para 15.
para 15.
Mm.
May I just read.
Yes,
In deciding bail application, an important factor which should certainly be taken into consideration by the court is the delay in concluding a trial. Often this takes several years, and if the accused is denied bail but is ultimately acquitted, who will restore so many years of his life in custody? Is Article 21 of the Constitution, which is the most basic of all fundamental rights in our Constitution, not violated in such case? Of course, this is not the only factor, but it is certainly one of the important factors in deciding whether to grant bail. In the present case, the respondent has already spent 66 days in custody, and we see no reason why he should be denied bail. So this was a case where observing Article 21 in 66 days itself, in a case of Unlawful Prevention of Detention Act, Unlawful Prevention Act, case, a bail was granted.
Mm.
And
Okay.
the other case, Sanjay Chandra, this is a 2012 case of Supreme Court, paragraph 20. From paragraph 20, 21, 22, 23. Paragraph
Yes.
21, 22, 23.
Mm.
I'll just read paragraph 21. and
Paragraph 20, 21, 22.
22 and 23, Lordship.
Okay. Yes, yes,
I'll just read paragraph 21.
yes.
In bail applications, generally it has been laid down from the earliest time that the object of bail is to secure the appearance of the accused at his trial by a reasonable amount of bail. The object of bail is neither punitive nor preventive. Deprivation of liberty must be considered a punishment unless it is required to ensure that the accused person will stand trial when called upon. The courts owe more than verbal respect to the principle that punishment begins after conviction, and that every man is deemed to be innocent until duly tried, guilty, and duly found guilty. Now, the other paragraphs are also relevant, but I will not place them to save lots of time. Paragraph 42 and 43, because this is a matter of under trial prisoner, where charge sheet has been filed, and this was a CBI matter of huge economic offense. Paragraph 42 and paragraph 43, I'll just read those two paragraphs and I'll rest my case.
42.
42.
Okay.
When the under trial prisoners are detained, when under trial prisoners are detained in jail custody to an indefinite period, Article 21 of the Constitution is violated. Every person detained or arrested is entitled to speedy trial. The question is whether the same is possible in the present case. And so what the Lordship has said is paragraph 43. There are 17 accused persons. Statement of the witnesses runs to several hundreds of pages, and the documents on which reliance is placed by the prosecution are voluminous. The trial may take considerable time. And it looks to us that the appellant who are in jail have to remain in jail longer than the period of detention that had been convicted. It is not in interest of justice that the accused should be in jail for an indefinite period. No doubt, the offense alleged against the appellant is a serious one in terms of alleged huge loss of state exchequer. That by itself should not deter us from enlarging the appellants on bail when there is no serious contention of the respondent that the accused, if released on bail, would interfere with the trial or tamper with the evidence. We do not see any good reason to detain the accused in custody, that too after the completion of investigation and filing of the charge sheet. So in fact, investigation being completed and filing of charge sheet is a good ground for the petitioners to seek bail. So in fact, filing of a charge sheet seems to be a good ground for the petitioners to seek bail. Their investigation over, charge sheet is filed. Here is also a case. Investigation over, charge sheet filed. Charges are yet to be framed. Evidence is yet to be laid. There is a stay operating. We are indefinitely behind the bars. So only on the ground, and Lordship will also look into one aspect. The prosecution has never argued the case that if we come out on bail, there is a possibility of we jumping bail, possibility of we influencing the trial. That is not their case. Their only argument here is that we have filed repeatedly with the same grounds. So therefore, what is the purpose of granting bail? The issue or the question to be decided is whether they will skip bail, whether they will jump bail, whether they will influence the witnesses. That argument has never fallen from the learned PP. The argument is only that yes, these are repeated bails. How could they do that? They should remain behind the bars for all times to come. There is no change of circumstances. So let them remain. My argument is no. Each and every passing day gives me a new cause of action to argue before the Honorable Court to seek bail because Article 21 is violated. These Honorable Supreme Court judgments have been categorically stating, do not put them behind the bars. My fundamental rights still exist, even though I'm behind the bars. Give me my liberty under Article 21. And on merits, a lordship has also recorded in the lordship judgment. On merits, if a lordship will see the charge sheet, it is clear that these three accused were never involved with the direct incident of that murder.
Anything else? You pass, Lordship.
Yes, Lordship. Deeply obliged, Lordship.
So just only, no? So their name may be taken, no? Or Mr. Sharma. A. Sharma, counsel for the petitioner. And Miss, I also had Miss Esmere, the public prosecutor.
Obliged.
Good class, sir.
Actually, in that, I feel that you accidentally, actually, it was